This is State of Michigan versus Kashawn Moore, case 2405779-101. Today is the date set for the bond redetermination hearing. Appearances, please. Mr. Ragnar, you're on mute.
Sorry, Your Honor.
No
Good
problem.
morning, Your Honor. Samuel A. Ragnan, P23-157 on behalf of the people. Good morning, Mr. Ragnan.
Good morning, Mr. Ragnan. Good morning, Your Honor. Ragnan, on behalf of Mr. Moore, who's here for bond redetermination.
All right, thank you very much. Mr. Moore, could you state your name for the record?
Yes, my name is Kushan Javon Moore Jr.
All right, thank you, sir. Today is the date set for the bond redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan, as to bond.
Judge, can I have a quick breakout room with Mr. Moore, just quickly, just real quick?
All right, Mr. Moore, can you hear me?
Yes.
All right, 1 second here. All right, recalling State of Michigan versus Moore. I'm going to mute you, Mr. Moore. Mr. Reagan, as to bond.
That's the bond. It's 100,000 cash surety, GPS tether, house arrest. My client's 27, Judge. He's employed every day. SMG clothing. He has 3 children, Judge.
Wait, 1 second. Mr. Reagan, Mr. Moore, I see that your hand is up. I'm going to let Mr. Reagan make his argument. And I'm going to let Mr. Ragnar make his argument. Then I'm going to give you a chance to talk to the attorney to clear everything up, put you back in the room. I got you on mute right now. It's because you got enough static in the back. I can't hear the other attorneys argue, so hold tight. All right, go ahead, Mr. Reagan.
Judge, and he also has, his child's mother. She's 7 months pregnant. She's actually dilating right now. He's trying to really get to her and get to the hospital, Judge. Now, Judge, this is not really, I don't believe it's a carjacking, Judge, because, the carjacking 101, you don't carjack people that you actually know and that you actually have a relationship with. So he knows this gentleman, Judge, and it's more to this story because, we talked about some different things. And I know that Mr. Moore did talk to detectives some about, what was going on. And it came out that Mr. complaining witness actually was touching on Mr. Moore's daughter. And it really infuriated Mr. Moore. And he probably had a moment where he snapped, and I think this is probably more of an FA than it is than a carjacking, because it's my understanding that the car was recovered according to Mr. Moore, because he didn't take the car, in that aspect, Judge. I think it was a heat of the moment situation. I think it was really a heat of the moment situation where Mr. Moore saw the person that touched his daughter, and it was saw the person that touched his daughter and was really upset about that. And that's why we're here, Judge. I think based on something of that nature. I don't think it's a carjacking. He knew this gentleman. I'm asking for a reduction in bond. I want him to be able to go out and see his child being born. I do get that he's charged with this, Judge, but I think once it goes to exam, I don't think carjacking is going to be necessarily a charge. Might have the FA, may have the FF, but I don't know about the carjacking, Your Honor.
All right, Mr. Ragnar.
Well, Your Honor, I agree. The $100,000 cash surety is not enough bond. I'm asking for it to be raised to $250,000. And the reason is that this is gentleman has a very past. Okay, in this incident, it's all on green light video. The complainant sitting in his car at a liquor store. He comes to there with a gun, assaults him with the gun, hits him with the gun. Okay, tells him, "I'm going to kill you." And he follows him in the store. Then he leaves the store, gets in the car, and drives away. Okay. Then subsequently, when the complainant picked him out of a 6-pack lineup of pitchers as the person that did steal his car and assault him. Now, the complainant also said that this defendant was dating his stepdaughter, I believe it was, his stepdaughter's boyfriend, but he didn't know the name. So when he was arrested, he gets interrogated, and he admits, Your Honor, that he did steal the car. He admits that he had the gun. He admits that he dropped the car off on some location. He threw the gun in a field. So, Your Honor, there isn't much doubt. He said he punched the complainant with his right hand, which is the hand he was holding the handgun in. And he did say he would kill him again before he drove off. So, Your Honor, very serious matter. It is a carjacking. It is an assault. But, Your Honor, he has pending cases. He has a home invasion second from 11/5/23. He's got a less than 200 malicious destruction of property from 3/5/24. He's got on July 26, 2019, he pled an armed robbery down to an unarmed robbery. Okay. So he's got a terrible past. I mean, he's got an assaultive past, armed robbery to unarmed robbery. I have the investigative reports on the home invasion. He goes in, steals numerous items. It's all on video as well. He has the malicious destruction of property where he's kneeling down by a tire of a woman's car. She goes out. She doesn't even know him. He punches the tires and then runs away from her. I mean, this kind of behavior is a danger, extreme danger to the public. I think, Your Honor, to anyone. And I'm asking for the bond to be raised to $250,000 cash. Thank you.
All right, Mr. Moore, I'm gonna put you back in with your attorney briefly. I'm gonna put you back into the room with your attorney so you can talk to him privately. Hold tight. All right, Mr. Reagan, is there anything further?
No, Judge, I think Mr. Moore was confused about the home invasions and malicious destruction of property, because I think one case is from November of last year, the home invasion second, but the warrant was just actually signed yesterday. And the same with the malicious destruction of property back in March. It was just signed yesterday on 6/17. So that's why he was really kind of floored. Like, I have no other cases, but they just have these new warrants. He has to be arraigned on these new cases that were just signed yesterday, back in November and back from March.
Yeah, I saw that as well. And it looked like they were both signed June 18th.
I think so.
Yeah,
So,
like today.
Yeah. So they're gonna have arraignments on those matters, so I won't use them for this purpose. Hold tight. Hey, look at one more thing. Mr. Ragnar, do you know if the defendant's on probation, parole, or awaiting sentence on anything else?
No, he was discharged from parole, Your Honor, back on 3/20. I think he was discharged. All I'm going to tell you, he was discharged from parole. I do know that for a fact. Thank you.
Okay.
I think it was 9/29/21. Thank you.
All right. I would note that defendant is charged with carjacking, felony firearm, assault with a dangerous weapon, or 2 counts of assault with a dangerous weapon. These are allegations. There was a statement alluded to in the investigator's report, and I won't use that statement to say what happened, when it happened, but I do know that this person was not supposed to have a weapon in any sort of capacity, out in public. I do believe that there is a dangerous situation for not only the complaining witness, but the public at large. And I think we've passed the point of clear and convincing evidence as to the safety issue. I would also note that it was a previous conviction for an assaultive offense. And for these reasons, bond is going to remain the same. Mr. Moore, your next date is going to be June 25th, 2024. Yep, Mr. Moore, you're not on mute right now. Just come a little closer. And I would advise you not to say anything, or you have the right not to talk. Anything you say could be used against you. But I know that you're raising your hand right now. Go ahead, sir.
I truly understand that. I truly understand that the cases that I'm being charged with and everything. I'm not saying that I have did it. I'm not saying that I have done it. I'm not saying any. I just wanted to understand that I have been convicted before. I have came to all my court dates. I never missed a court date. I'm not saying I just don't understand why I can't even get 10% on this so I can at least fight my case from home. I got 4 kids at home that my baby mama could really not handle this. My daughter wake up screaming every day and every night, talking about how Tyrone is touching her literally every day. Sir, I'm not lying to you. I have videos of these things.
Sir, I'm going to stop you because I know you have a defense and I don't want you to say anything that could get you that they can use later on. So, I would strongly advise that you don't talk. You're going to get an attorney. You're going to have a chance to fight these charges. I made my ruling as to the safety of the community. I do believe that there's an inherent danger. I know this person's not supposed to have a weapon. And at very least, I know, at least from according, to everything that I've heard, that there's a weapon involved in this matter. So bond is going to remain the same. It's potentially unaffordable. It's essentially a remand. That concludes the hearing.
Thank you, Your Honor.